The issues accepting foreign documents in Polish law is a little bit complex because our analysis requires not only the perspective of the procedural rules governing the admissibility of the documents as evidence, but also the formal and substantive validity of the legal act reflected in the document. Of course, the separate matter concerns the requirement to provide a translation of any document drafted in a language other than official language of the Polish Republic in Polish. But this problem, because in Polish procedure, from time to time, the documents must be prepared by the sworn translator. So the translation, simple translation cannot be used, for example, in notarial procedure. But about the translation of the documents, I will speak a little bit later, so maybe in the next conference in the spring. Also, we have some specific nature of civic status record because the center situation, Polish law requires a transcription of this document. That this is such procedure, administrative procedure, which is the transfer of the context into Polish civil status register. Some other problems in Polish treatment of the foreign instruments is the problem of the recognition of foreign court judgments. We have two basic models. It depends from the date of issuance of this judgment, foreign judgment. But about this, about this issue will be the presentation of my honorable colleague, Mr. Łukasz Piebiak, in 20 minutes, I hope. And so I focus now on some general principles governing the treatment of foreign documents in Polish civil law. Because I will tell you something about the three main aspects concerning the treatment of foreign documents. Because in Polish civil law, to produce the document, several issues must be asserted separately, each on the basis of distinct legal provision. First is the probative value of the document. Second is the law applicable to the form of the foreign legal act reflected in this document. And the third one is the law applicable to the subject matter, so some material problems of that legal act. The first aspect falls within the scope of the procedural law, while the second and the third aspects are the domain of conflict of laws. The acceptance of a foreign document in civil proceedings and is possible only if all these three aspects are assessed positively. A negative finding in any of these areas necessarily results in refusal to recognize the document. For example, the notary must refuse to perform a legal act on the basis of the foreign, for example, power of attorney, because 90% of the documents coming to Poland from abroad, they are in fact powers of attorney, which are used in Polish civil procedure. There are some other kinds of documents, but I think 90 or over 90, maybe 95, 99% of the documents used every day before the Polish notary or before the Polish court, they are foreign power of attorney. What is important, these three aspects are not interconnected. The fact that the document has probative value does not imply that the legal act reflected in content is formally effective. Of course, or a bull, vice versa. The fact that the document is formally effective does not mean that the document has probative value as such. So we have really to have these three aspects well done from abroad to use the document, to have the possibility to produce the document before the Polish court or Polish notary. Let's go to the main article in Polish Code of Civil Procedure, is Article 1138 of the Polish Code of Civil Procedure. According to the first sentence of this article, most of foreign official documents have the same probative value as domestic official documents. This provision states, the sentence is clear, foreign official documents have the same probative value as the Polish official documents. However, in the second and third sentence of this article 1138 of the Polish Code of Civil Procedure, There is specified a situation in which a foreign official document acquires probative value non-ex lege, so not every one document from abroad can be used as such, has the probative value, but only upon consular legalization, so authentication of the document. This sentence provides a document concerning the transfer of ownership of real property situated in the Republic of Poland must be authenticated by the Polish diplomatic mission or consular office, and the same requirement applies to document whose authenticity has been challenged by a party. So the only documents excluded this ex lege probative value are those which are in this sentence 2 and 3. They concern the transfer of ownership of the real property located in Poland, or they are documents whose authenticity has been challenged by a party. So only these two special categories of documents require legalization by a Polish consul if they are to be used in Poland. Otherwise, they possess no probative value. As I have told, mostly these documents, they are power of attorney authorizing legal acts resulting in the inter vivos transfer of ownership of real property. They fall squarely within Article 1138, sentence 2 of the Code of Civil Procedure of Republic of Poland. What is important, this provision applies en bloc, so to all powers of attorney, except, of course, where international agreements provide otherwise. I will discuss this a little bit later. In practical terms, the only foreign documents they may in reality fall under this legalization requirement are powers of attorney to transfer ownership of real property, and possible there's also another category of documents, disposal consent for the sale of real estate as required by Article 37 of the Family Guardianship Code. Other documents concerning the transfer of ownership of real property located in Poland, such as a contract transferring ownership of foreign court judgment awarding such ownership, will not have legal effect in any event because due to Article 25 of the Private International Law Act or due to exclusive jurisdiction of the Polish court. But this third sentence of Article 1138 applies ad casum. It means that the authenticity of the document must first be challenged by the party before a civil law notary or a court may invoke the requirement of legalization. If there is no challenging document, so it means that the document has probative value. However, a notary or court is not empowered to impose a legalization requirement and deny the authenticity of the document for filer to do so, because as it was mentioned before, the authenticity of this document has been challenged by a party, not by an officer, judge, or the notary. What is also important, the parties may agree that a given act will require documents bearing a legalization clause or an apostille clause, even if such requirement does not arise from the applicable law. So according to the inter-parties agreement, it could be something like imposing legalization clause on the documents or apostille clause on the document because parties decided to select such procedure. Nobody know why, but it was the will of this. They wanted to do it, but it wasn't in fact a practical requirement from the Polish civil law procedure. But according to the article 1138 sentence, it's possible to do like this. When the legalization clause is required, according to Article 1138, second and third sentence, the absence of such a clause results de jure in the non-existence of the document. So, such legal act performed on the basis of such power of attorney amounts to an act carried out by the falsus procurator, so without any power of attorney. Of course, there are procedures to use such an act, but it's not like an act done with a valid power of attorney in Polish law. Okay, in some countries, in a number of countries worldwide, legalization clause do not apply even when foreign documents would otherwise fall within the scope of Article 1138, second and third sentence of the Polish civil law procedure. There are, of course, two situations. First, where there is a bilateral agreement between Poland and the states whose authority issued the document, abolishes the requirement of the legalization. In the situation of Poland, and I've seen the same is in the situation of other countries of the Middle Europe. It's all nearly 40 states. We have relation with nearly 40 states, which excluded legalization, or in which the legalization was abolished. Of course, it is a heritage of communistic time because mostly these agreements were concluded in 70s or 80s or 90s, not so many, but they are very important and they have some liberalizing, they are really liberalizing the agreements. The transfer of documents is liberalized because of these regulations of bilateral agreements. And of course, there is a Hague Apostille Convention which applies in relation between over 120 states. It's important, but only partly important from the Polish procedural point of view. Because where the bilateral agreement exists, legalization is entirely excluded. Where both states are parties, the Hague Convention legalization is replaced by their certification with an apostille clause. But if the state is party but to bilateral agreement and to the Hague Conventions, which is relatively common, the bilateral agreement prevails as lex specialis. Moreover, Article 3.2 of the Hague Convention itself expressly gives priority to bilateral treaties. And usually a bilateral agreement generally abolishes the legalization requirement in full, although it does not prohibit legalization itself, which may be still carried upon the request of the document holder. It's in Polish practice, it's really common because from time to time the people require the legalization from the consul. For example, in China, we have the agreement which generally abolishes the legalization from China. The documents originating in China People's Republic. But in fact, because the documents are written in the strange language, they are written in there are so many business there is the bond with China, and there is the big money concerning the usage of such documents. So from time to time, the people which are going to produce the documents from China wanted to have the legalization, and they go to Polish, not now consul, because China is since 2 years party of the Hague Apostille Convention, but before 2 years they have gone to Polish consul and they told, okay, give me a legalization clause, I will pay for it, but I need it because for me it's more certain. I would like to have such clause because it's important for us to show that it's not false. But according to Polish law, of course, it's generally according to this agreement, legalization was generally abolished in relation with China as with other 40 states. The provision of the bilateral agreement, as I told, is lex specialis and override national law, therefore exclude the application Article 1138 of the Code of Civil Procedure. Any official documents in a state that the party to such an agreement automatically possess full probative value in Polish civil law translation. Also, if there is, of course, this document concerns the ownership of the Polish estate. What's important? Numerous multilateral EU and international instruments, including those binding Poland, refer to abolition of the requirement of legalization for documents falling within their scope. Owing the narrow range of situations in which Polish law requires legalization, documents covered by instruments are in practice never subject to legalization of the Polish Code of Civil Procedure. As a result, the relevant treaty provisions are of no practical significance in Poland. So if we do not need legalization for such a category of document, so it's no sense to sign to conclude such agreements. Of course, the Poland has signed this agreement because the convention are reciprocal. So it means that maybe Polish documents have a better treatment in these countries. It's reciprocity of effect of the treaty. But from the point of view of Polish procedure, there is no sense there. These documents are entirely these conventions are entirely irrelevant for Poland. The same for the same reason we have the same situation. We have the regulation 1191 on promoting the free movement of the citizen and simplifying requirements for presenting certain public documents. It's a called European legalization regulation. It's entirely irrelevant from the Poland as a receiving state. And the same, we have also the similar reason as for the Athens Convention of Civil Status Record. It's wholly irrelevant. Also, the European Convention on Diplomatic and Consular Documents is also of negligible practical significance in Poland and also in our Middle European countries, because consular notarial documents are issued extremely rarely in practice, and in particular never used in matter concerning the transfer of ownership of the real property located in ascending state in Poland. From the consular law is ascending state. Precisely only the category for which legalization may theoretically be required under the Polish law. So these instruments are really, they do not have any practice in this area. The only one instrument which has significance in this area is the Hague Convention of the requirement of the abolishing requirement of legalization of foreign public documents, called Apostille Convention. But contrary, what's important, contrary to its title, does not abolish the legalization requirement. It replaces classic consular legalization with certification of the competent authority of the states in which the documents originates. This certification is done by the apostille clause. What is important, the Hague Convention distinguishes between the potential and actual scope of application of the convention, because Article 1 states that apostille clause may be applied to all documents used in civil, administrative, criminal proceedings, with the exception of commercial, customs documents, documents drawn up by the consuls. But actual scope of the application in this in every state depends on the category of documents for which that state requires legalization. Let's take a look into Article 3, second sentence of the Hague Convention, which states, however, the formality mentioned in the preceding paragraph of this apostille convention cannot be required when either the law, regulation, or practice in force in the states where the document is produced, or an agreement between two or more contracting states have abolished and simplified it or exempt the documents itself from legalization. It means that the apostille clause may be required only if the receiving state's national law requires legalization. So for documents in question in Poland, there are two categories of the documents in which the apostille clause is required. There are documents concerning the real estates located in Poland, and the documents whose authenticity is not correct from the point of view of the party of the treaty of the agreement. Okay. And of course, if there is, I've told before, if there is a bilateral convention, Hague Convention, bilateral convention prevails. Let's go to the second question. So the form of the legal act under Polish law. The form of the legal act is governed by the Article 25 of Private International Law of 2011. Of course, the legal act is formally valid if it complies either with the law applicable to the act, so-called lex causa, or with the law of the place of performance, lex loci actus. And most commonly, a power of attorney in civil law practice, including power of attorney to transfer ownership of real property, is governed by these rules, either by lex causa or by lex loci actus. I think it's 90% is governed by the lex loci actus. But it's worth to mention that the Polish law also contains specific conflict of law rules addressing the formal validity of the foreign legal acts in particular categories of matters. This concerns dispositive acts relating to the transfer of ownership of legal property, as well as acting company law concerning the existence of legal person, formation, division, liquidation of the legal person. Article 25.2 of the private international law provides that in this case, compliance solely with the form required by the lex loci actus is insufficient. The form prescribed by lex causa must be satisfied. So it can be done, but only before the notary, who is a Latin law notary, so not in, for example, common law system. It's also worth noting that Article 25.2 of the private international law, this for the legal act relating to real estate, cannot in practice be performed inter absentis, when the parties are located in different states at the moment of concluding of the acts. For example, the offer is made abroad and accepted in Poland. In such a situation, the transaction requires compliance with the Polish notarial form in that jurisdiction. The important issue is also the problem of the lex recita, which concern divergences arising from bilateral treaties, because several bilateral treaties binding on Poland, in addition to this general rule I told before, provide something like the law of the place where the real estate is situated, it's called rex licita, which applies exclusively to the form of all legal acts concerning the real estates. These rules we have with 20 countries. They are countries strict from our area. Of course, there are some countries a little bit exotic like Vietnam, but mostly there are countries from our area, so Central Europe and Middle Europe and East Europe. And there are, of course, I think Croatia, yes, Slovenia, Serbia, of course, Hungary, Slovakia, Czechia, and so far. Consequently, a notary from one of the states may perform such an act only if the resulting instrument is functionally equivalent to a Polish notarial deed. Certain local particularities in Central European notarial practice are very well known in this respect. For example, if the Croatian notary, Javni Bieżnik, wants to make an act in Poland for something like power of attorney, which should be produced in Poland, he has to conclude this power of attorney in a notarial deed, because it couldn't be accepted if only the certification of a signature of the party. Of course, if there is a not big legal turnover because the countries, it could be a problems. But usually in our Central European region, this legal turnover is quite big. So this power of attorney is done according to the lex recita regulations. Lex recita requirements are accepted in Poland. Interestingly, these agreements do not necessarily impose equally strict obligation in the opposite direction, because power of attorney, for example, executed in Poland must comply with the form required by the law of the states where the relevant real estate is located, for example, in Bulgaria. If that state does not require a special form for powers of attorney, it is the situation of Bulgaria. The instrument may easily be executed before a Polish civil law notary, also, for example, in a form of certifying a signature of the mandatory. Okay, and the last question I am just finishing is the question of material issue of the legal act. There are two big problems, because in this substantial question of accepting the Polish document and its consent, Polish private international specify only one problem, in fact, one question which is important, because we have special regulation concerning the material issues concerning power of attorneys, because in accordance with Article 23.1% of the private international law, this regulation permits a choice of the law applicable to the substantive effects of the power of attorney. The applicable law might be determined by the principal's express choice, so we can make a choice law from the perspective of using a power of attorney before a Polish authority, a court of the civil notary is essential that it be subject to Polish law. So it's good to make a choice of Polish law if you produce the Polish to Poland, if you produce to Poland from foreign countries the power of attorney. If there is no choice of law, so it's something like the cascade of connecting factors. If the first connecting factors cannot be used, so we will go to the second connecting factors, and in 90% of cases, we will stop on the third connecting factors in this cascade. This cascade is provided in Article 23.2 and stipulates that there is no choice of law. First, if the attorney is a legal person, the applicable law is that of that state in which the attorney has its seat. So if he has his seat, it means in the Polish law that he is a legal person. If the attorney is a natural person acting on the permanent basis with the principal's enterprise, and the principal is the interpreter, the law applicable is the law of the country in which the enterprise is located. And finally, if there are not such two situations mentioned before, so the governing law is that of the states in which the attorney actually performs or is expected by the principal to perform the representation. In the case of power of attorney intended for use of Poland, this will be necessarily be the Polish law. We have also some bilateral agreements in which the law applicable to the power of attorney is predetermined. So in this situation, the choice of law is irrelevant. There is no possibility to choose the law of for power of attorney. For example, Hungary, from Croatia, from Serbia, and so forth, because we have a bilateral agreement, and in these agreements, the material law is determined. For example, for real estate is always lex reside, so the law in which the real estate is located. So thank you very much. It will be enough for today. Thank you for your attention. And I would like second time to express my biggest gratitude to especially to the members of this program from our Central countries, Croatia, Serbia, Slovenia, and Armenia. Thank you very much.